Good. Well, we'd like to welcome everybody to today's webinar. This is Todd Emmett. We're coming to you from the Anaheim Chamber of Commerce today. We're excited that, as we all know, we've entered the yellow tier here in Orange County, and we've had sessions on that, so I won't go into a lot of that. But if you don't understand the yellow tier, you can go to the Anaheim Chamber website at anaheimchamber.org, and there's a link about COVID resources, and a whole link about the tiered system and what's allowed during the yellow tier. As we say that, we also know that in the state of California that June 15th is a magic date that's being talked about as being widely open as a state. Some discussions about mask mandates and a few things beyond that. But for all things that we're hearing after June 15th, most venues, theme parks, sports, concerts, will be allowed to go back almost to normal. There are a lot of questions from the chamber members and others in the community about what happens with requiring vaccines. Can it be required by employers? What's happening with workers' comp? What's happening with OSHA guidelines? A very live topic as the CalOSHA Standards Board is meeting as we speak. And we have Robert representing the CalChamber that'll give us an update on what's happening there. We may not know a lot of clarity today, but we're going to give you what we do know. So there are many things happening. There are some amendments that are being proposed to the CalOSHA's emergency temporary standards. And those are, as we said, that's going on live. And so I'm going to first turn to Rob with the CalChamber for a quick update on what you're hearing. And then our main speaker today is Ashton Riley, an attorney from Fisher and Phillips. So Rob.
Perfect. Thank you, Todd. Afternoon, everybody. So the quick update on CalOSHA. So the background on today, the vote was happening, is that as you guys, I'm sure all familiar, the COVID-19 emergency regulation has changed the workplace for the last year. And they're looking at amendments today, which would change significant portions of that going forward, in some ways lightening them for employers and in some ways adding huge new burdens. The update on today's vote is that it actually was delayed until the first week of June because CalOSHA staff realized that recent CDC guidance being released saying that all vaccinated people can basically go without masks in all situations was contrary to what the COVID-19 emergency standard was going to provide. And so they wanted to pull it back to try to slightly adjust those mask specific provisions. On the whole, they're not going to change tons of it, but you'll see that small change. If you haven't seen the text of the amendments that are coming, I would just tell you, I anticipate them passing largely as they are drafted by CalOSHA, and I will put a link in the chat so you can see those as they're coming, or rather so you know what they will look like. There is the new amendments. That was the draft preceding today's vote. There will be small changes to face coverings in there, so those aren't perfect, but they'll give you a good sense. The biggest two things I'll flag for you quickly, and then I'll hop off so you leave time for Ashton. Are first, make sure, particularly if you have an indoor workplace, you take a look at the requirements for N95s. Under the new amendments, employers will have to have N95s on hand for most of you starting July 31st to be available to employees who are not vaccinated. So if your population is not entirely vaccinated, you're going to want to look at having N95s on hand. So take a look there in the standard. Second thing I want to flag for you related to vaccines is prior to now, the standard did not reflect vaccination in any way. Your vaccinated, your unvaccinated employees were treated identically. Now, with the changes coming out with these amends, when they are passed, vaccinated employees will have more freedom and you'll have less need to space around them than unvaccinated employees. That brings an obvious question. How do we verify who's vaccinated? How do we keep track of that in documentation? Obviously, that's the question. That has not been clearly addressed. CalOSHA has not been perfectly clear on what documentation is necessary or how you'll have to show that. So that remains an outstanding question I can't address for you. Best practices, I would say, is, of course, as I'm sure Ashton would say, is consult with your counsel, because especially when you're wading into murky waters, right, you want to get the best guess from the best guessers, and counsel will be the best guessers in that scenario. So those are the two biggest pieces I would flag there. There's a lot in this standard. Obviously, it's 30 pages long, but the last thing I'll say is, Todd mentioned June 15th. That's the date the governor's been talking about. Presently, the draft amended regulation also uses July 31st date as a threshold for a couple of changes. including social distancing rules and face coverings. So you'll want to look at how that changes on July 31st. Again, the text I'm sharing with you now is the draft as of today. There may be some tweaks coming into that the next week or the week after, slight changes, but I don't expect them to change the overall architecture, including that July 31st date. I expect that to stay largely in place. So take a look at that. And Todd, I don't know how you want to do any questions. I have 2 more minutes, or if I should just pass over to Ashton. How shall we do it?
Well, thank you very much, Robert, for the live update. And we know it's very fluid, and thank you for the link. I think Ashton's going to jump into that. So thank you very much. And as we get questions, if there are things that we can't answer, we'll get them to you, and then we'll route them back out to the email list from this call. So thank you very much for your time.
My pleasure. Best of luck, everybody. Stay safe.
Great, thank you. Well, it's my honor to introduce Ashton. Ashton specializes in representing employers in class and collective actions, employment discrimination, harassment, and litigation and trials. He was named one of Ones to Watch by Best Lawyers Magazine earlier this year. He graduated UCI and Loyola Law School. And today, Ashton will give us a refresher on the current standards, vaccine policies and testing, as well as predictions on the proposed regulations that we've been discussing, and what changes related to CDC guidance and the potential timing. With that, welcome, Ashton.
Thanks, Todd. So I can't see everybody out there, but it's great to be here. A little bit of background. I'm a senior associate at Fisher Phillips here in Irvine, and we are a labor and employment firm practicing exclusively in that space. We are nationwide with over 30 offices in pretty much every major city. And so today we're going to go over a series of topics, and I got to address the elephant in the room, which is that I prepared, probably half of this presentation on the new regulations, just to learn yesterday that they aren't going to adopt them. So Robert's message is actually very welcome, because I have some slides to sort of go over the proposed changes, and if they're not going to change much on what was already drafted, then this will actually be very beneficial, hopefully for every member. So I'm going to go ahead and share my screen and go over some slides here just to give you guys some information. If I can just set this up. All right. And away we go. All right, so first topic up, hot one right now, obviously vaccines. It's probably one of the biggest questions that we get routinely is, can we mandate them? If we do, what are our obligations? What are our risks? Or should we simply recommend or make vaccines optional? Luckily, we have some guidance from both the EEOC as well as the Department of Fair Employment and Housing, which is the California equivalent, on what employers can or cannot do. And so to answer everybody's question is that both agencies have said that employers can require workers to get the COVID-19 vaccine. Of course, with everything in the law, there's a caveat. And that is whether or not employees have religious or medical objections. So under both federal law and state law, just like when somebody has some type of religious practice or some type of medical condition, you have to engage in what's called the interactive process. And so with vaccines, it's the same thing. And so under federal law, the Americans with Disabilities Act obligates employers to engage in a reasonable what's called the interactive process to determine whether or not there can be a reasonable accommodation. And so typically you see this, when somebody has some type of injury or some type of condition. In the vaccine context, it's somebody will often present to the employer with a doctor's note which says they're at a risk of some particular condition that the vaccine may aggravate, or otherwise it could be a problem for their medical condition. What happens is that at that point, the employer is under an obligation to engage in the interactive process. Just like if somebody in a wheelchair asked, for a lower desk, you shouldn't outright just say no and turn them down. And so a couple considerations here as far as once you engage in the interactive process is that you want to be very careful. You really only want to gauge enough information to determine what accommodation you need to make or what you should consider. And so you really don't want to get into something that would invade in their privacy or otherwise learn too much of their medical condition such that, it could be argued that you use that condition to punish the employee later. And so in the vaccine context, there's really only a couple of accommodations that have come up so far, at least in my practice. And it's if you're going to mandate vaccines and somebody has an objection, potentially you make an exception for them. That's the most common one. The other more common accommodations are, allowing the employee to continue to engage in remote work if that's possible, or potentially a leave of absence such that potentially when, CalOSHA or other agencies loosen standards, that the person could return to work even unvaccinated, just with other protections in place. So as the slide mentions here, as far as allowing an exception, if you're going to make an exception, it's very important that you demonstrate that you considered your options. That's actually for two different reasons. One, because it's good to demonstrate that you engaged in the interactive process, but also so that way you can show that you're making the accommodation for the employee. Now, this raises the question, if you're having a mandatory vaccine policy, what happens if somebody doesn't want to get vaccinated, or you want to exclude them from the workplace because they're refusing to get vaccinated and you cannot come up with another accommodation? There's a couple different options here, and thankfully the EEOC has weighed in. So can you force them to simply stay home? The answer is maybe. So this gets into whether or not the employee, if they are unvaccinated, would they pose a direct threat to the workplace? If so, then you have a general duty to provide a safe and healthful workplace. And if they're going to be working in close proximity, let's say we're in the middle of an uptick in cases, potentially that would be. But it's going to take an objective analysis. And that's actually probably good advice for everything related to this entire process, is that you want to slow things down, look at each situation. If you need to call your attorney, go ahead and do so. But just really look at all the facts before you make particular employment considerations. And so a little bit more about the direct threat and talking about some of these objective factors. You want to look at, well, the duration of the risk, how long are they going to be potentially exposing others? How long before that risk will potentially alleviate, whether or not they're going to get vaccinated, or if standards are going to loosen. The nature and severity, we're all pretty familiar at this point what the sort of potential harm could be if somebody gets COVID. In the workplace, it's not just about one person getting sick, but it's actually about one person getting sick, which turns into 3 people getting sick, which turns into 20 people getting sick, and then you're in the middle of a major outbreak. Let alone if you have some type of impact on your customer base, which opens up sort of general liability concerns. Where you potentially have some wiggle room is the 3rd and 4th bullet points, which is the likelihood that potential harm will occur. And that's because over the last year, a lot of companies have taken steps to, as far as social distancing, partitions, masks, those types of things. So if somebody's not vaccinated, but you're otherwise having them comply with, a whole plethora of other safety concerns, potentially there's not going to be a ton of harm, potential harm that's going to occur. Similarly, that's going to reduce sort of the imminence of that potential harm because you're going to reduce that risk. So for example, as I mentioned earlier,
All right. Let me just double check. I lost my phone audio, so let me confirm.
You're good, Ashton. We can hear you. You're good.
Okay, great. Audio's back on. Wouldn't be a webinar without some technical difficulties. So as I mentioned earlier, one of these situations is somebody with a medical condition, comes to you and says, look, I can't take the vaccine. It's going to cause me a potential problem. First thing you do is, well, what other accommodations can we make? If you can't get vaccinated, can we otherwise allow this employee to continue working for us that won't pose a direct threat to them or your other employees? One of the big ones, as I mentioned earlier, is, well, can they do things remotely? Obviously, that's not going to be an option for, my manufacturing clients, some of my hospitality clients, maybe even some of my retail clients, where it just requires people being there. Whereas, potentially the more, finance, maybe some other white collar positions, or me as an attorney, obviously I could work from home and it probably wouldn't be a big problem. But as I mentioned earlier, obviously you can consider other accommodations in the workplace, such as social distancing, masks, and the rest that we've been dealing with for a year. So as Robert was talking about earlier, let's see, is this? All right, proof of vaccination. So assuming you have a mandatory policy, or if you have maybe a recommended vaccination policy, the question is, well, what do we do in terms of proof? Is there potentially, can we ask people, simply to provide their card? What do we do? So the EEOC has said that this is not a medical examination, which is important because if it were, then there's a whole host of other considerations that you need to make, and it just becomes incredibly much more difficult. So when you're asking for proof of a vaccine, then you still want to, as I mentioned earlier, only ask the information you need to determine that they are vaccinated. We don't want to get into their medical history, why it took them so long to get the vaccine, really nothing beyond vaccination status. And if you're asking for proof, if you're going to make a copy of that document, then that becomes a medical record. And as a medical record, you need to keep that in a separate, secure file, as opposed to, for example, a personnel file where you have an employee's application and all those documents. And so if you are going to do that, then you do need to take certain steps to protect that information. And if you're familiar at all with the CCPA, which is the 6th bullet point down, the California Consumer Privacy Act went into effect about a little more than a year ago. And if you're subject to that statute, then you need to provide notice in advance of the information that you're going to be gathering regarding their vaccination status and what reason you're going to be keeping it for. Now, it's a technical law. It typically applies to larger employers. If you have any questions, I would very much advise, talk to your attorneys. Feel free to reach out to our firm or even look at our legal alerts, and we have some information on that statute. Similarly, if you need template forms as far as CCPA notices or other documents, that's something that we can provide for you as well. And lastly, the very last bullet point is that I already mentioned that you shouldn't be asking about prior medical conditions, but there's an additional federal statute, because obviously we don't have enough of them, called the Genetic Information Non-Discrimination Act, which is very similar to learning somebody's medical history, but it's about their sort of genetic information, predispositions, and we're not supposed to get into that type of information. Now, should you ask? This has been a big one. Do we go on the honor system? I think I read in the news some larger international companies will be simply going off of the honor system for their employees to tell them whether or not they're vaccinated. I think that's risky. Some of my colleagues think that that's a bit risky. And potentially you might want to actually request this information under or with some of the cautions that I already discussed in mind. Particularly if you're going to have a mandatory vaccination policy, and if you want to take advantage of some of these looser standards, which we'll get to later, then you're going to want to have that documentation potentially. Now, as far as what form of documentation, Robert alluded to this earlier as far as, well, what's gonna count? CalOSHA hasn't said. The closest that we've been able to find is actually, I believe it's in the blueprint for a reopened economy under the private venues and sort of entertainment space, which has talked about potentially a vaccination card, a photo of the vaccination card, which is either its own document or stored on a phone, or documentation from a healthcare provider. I did want to point out one thing, which if you have noticed yet, or if you haven't noticed yet, is that online, much like most things, you can simply Google vaccination card and you can buy one or download one and simply print it out. And it's actually gotten to the point that I think it's the California Attorney General commented publicly advising Californians not to purchase or print fake vaccination cards. So that raises a question as far as, well, you know, how much can I trust an employee presenting a card? And as I mentioned earlier, it really depends. You know, if you have reason to question documentation that an employee provides, you got to be very careful as far as questioning them about the document, because again, you might learn some things that you don't necessarily want to learn or invade their privacy. Best practice would be to simply ask them for it, you know, a simple inspection, much like you would during the I-9 process when you're looking at an employee's social security card or their other authorization documents. That's probably a good rule of thumb, which is that if you have a good faith belief that it's valid, then that's probably going to suffice. Again, a lot of this is subject to change, but that's what we're seeing thus far. So just a couple recap slides as far as vaccine policies. Generally, you can require them. You just need to stay mindful of any medical or religious objections. In those cases, you engage in the interactive process, document it if you can, consider reasonable accommodations. And one thing that I've gotten into the habit of advising clients is that after you come up with a plan with the employee, make sure you document that, whether that's a follow-up email, a letter, a memo to their file, something that says, this is what we decided is going to be a reasonable accommodation. And if possible, get some buy-in from the employee. The second to last bullet point is actually really important, and it's where a lot of employers get tripped up. And that's where, you know, maybe everybody on today's webinar, you know, depending on, you know, you're an HR professional, you're the owner of the company, you know what to do because, you know, you've been to these webinars, you're keeping up on the news, but maybe your rank and file supervisors or managers are not. And so it's very important that whoever is going to be engaging or making these decisions is trained on the process. Because if, as that last bullet point gets into, I mean, if you don't do it at all, it's almost just as bad as denying somebody an accommodation. Second piece of advice is figure out what it is that you want to do. A perfect example is our firm, you know, we went with a strongly encouraged policy earlier this year. And so that has taken multiple different forms, you know, communications to all employees, explaining this is what the policy is going to be, providing information as far as, you know, information on the vaccines, information on where to get vaccinated, the process, and just making it easier because most employers would like their employees to get vaccinated so that way things can get back to normal. And so going just short of mandating it, really all you can do is just make it as easy as possible and remove the barriers as much as possible to getting vaccinated. Now, so here's some other sort of positives, as far as why it'd be good to develop a policy regarding vaccines. For this slide, I really would like to just focus on the last bullet point, which is, just because an employee gets vaccinated, it doesn't stop. That's probably going to be the majority of the rest of the webinar today. But once somebody gets vaccinated, it's not necessarily the end of the story just yet. So I mentioned that, our firm has a lot of template forms and things, and we have some sort of one-page handouts that I can share with Kathleen and Chris and the chamber to sort of distribute. But if you ever have questions on a lot of these things, we have dedicated web pages to a lot of these items. So, I'm aware, calling an attorney is not exactly what somebody wants to do all the time. As much as I love talking to clients, they don't always want to call me. So our website actually provides a lot of very helpful resources, which would be a good starting point to sort of get some direction before you have to develop a relationship with an attorney, or just so that way you can sort of figure out some basic steps you can take now to sort of get prepared. All right. So obviously there's been a lot of action as of late, particularly in terms of the CDC's guidance, as well as California. And this is going to be just a little bit of the recent updates before getting into some of the CalOSHA proposed regulations. So the good news, CDC, basically, if you're vaccinated, you can go out into the world, do whatever it is that you want to do with very little risk, so long as you're not in a hospital or another healthcare setting, which when we first read this was, well, fantastic, but what are we doing here in California? And so the CDC was very clear that, look, this is their guidance. If you have other federal, state, local jurisdictions, which have more restrictive measures, you still have to follow those. The CDC does not supersede those. And just for informational purposes, as far as who is fully vaccinated, is not simply the day you get your second shot for Pfizer or Moderna, or the day you get your single dose of Johnson & Johnson. It's actually the 2 weeks after, so that way the vaccines can sort of take effect. And as I'm sure everybody's familiar with, which is this graphic, obviously is very fun, looks fantastic, and is a great incentive if we didn't already need one for folks to get vaccinated if they'd like to. The CDC has also come out and talked about sort of testing and addressed that in relation to vaccinations. And this is actually a pretty important one, which is that fully vaccinated people can refrain from testing following a known exposure, with limited exceptions for correctional detention facilities or homeless shelters. Now, one thing I want to be very clear is that that assumes that the vaccinated person does not develop symptoms. As some of us have read, there are instances of what are called breakthroughs, or somebody just is particularly susceptible, such that they end up becoming a COVID case even though they've been vaccinated. So all this obviously sounds great. We're getting back to normal. Businesses should reopen, and all this is, it's a brand new world. Let's get to it. But it also leaves some really important questions, particularly, in the employment context. Just because the CDC says that people can go out into the public and, go to their barber, go to their hair salon, indoor movie theaters, the rest of it, well, what about the salon? What about the movie theater? What are they supposed to do? What do they do with their employees? And so similarly, what do we do for people coming to our business? Do we ask them for proof of vaccination? And thus far, it's, in California and at the federal level, There's protections for denying somebody service on the basis of a medical condition. If you saw those viral videos about people that didn't want to wear masks, a good amount of them were saying that businesses were discriminating against them because they couldn't wear a mask because of a particular medical condition. And it's probably going to size up the same thing for vaccine status. And we're really already seeing a little bit of it in the news. And it's a legitimate concern. If you're going to, they could say it's because, they're unvaccinated because of a medical condition and that they're being discriminated against. Similarly, you would be gathering medical information or private information on, on the public, which may come under that statute that I mentioned earlier, the CCPA, the California Consumer Privacy Act. And so some jurisdictions are flirting with the idea of vaccine passports. China, Japan, Thailand, all announced programs to do some type of program. I think Israel was the first to implement some type of digitized program, and New York State has mentioned that they plan on rolling out that type of program. Orange County, there's proposed a pilot program, which ultimately, was not adopted because there was a good amount of opposition, but it's going to be really interesting to see, how this begins to play out as vaccines become even more prevalent and businesses begin to reopen. Now, as I mentioned, the CDC has talked about, people entering public in terms of vaccination, and that is the public, not necessarily from an employment standpoint. But federal OSHA has come out with this wonderful quote, which says, that they acknowledge that the CDC has issued this guidance, which talks about activities outside of healthcare, but they're currently reviewing the guidance and will probably issue their own regulations. Until that's complete, they are at least deferring a little bit to the CDC for information as far as how to protect fully vaccinated workers, which is good news, because if well, we'll get into it, but if California takes a similar, Health and Human Services takes a similar stance, then hopefully CalOSHA will follow, in line as well. And so, as we've seen recently, the state has talked about how there are some things that fully vaccinated folks can do. You can, spend time with other fully vaccinated people without masks or physical distancing. Typically in work that's outside, we haven't made it inside yet, but we'll talk about that with the proposed regulation changes. Similarly, you can refrain from face coverings outdoors when, except when attending crowded outdoor events. One thing that has stayed in place, and I wanted to mention that because this is the Anaheim Chamber, we're in Orange County, we have Knott's, we have Disney, is that as of now, California still has the travel advisory in place, which is restricting theme parks to in-state guests. And so
Hello, everyone. We just lost a connection. He'll be back on in just a minute. So give us a second. We do, as we're waiting for him to sign back on, if you have any questions that you would like him to answer, please use the Q&A feature down in the bottom and we'll go through them. I already see one question so far. So when Ashton finishes his discussion, we will head straight to the questions. So just wait 1 second and we'll make sure that we connect with Ashton. I'm sure that he's struggling with his connection and is frustrated. So be right back. We'll see what's going on. Stay tuned. Yay, you're back. Sorry about that, Ashton. Looks like we had some technical difficulties.
Bounce me out?
Yeah, but thank you for coming back so quickly. I just reminded our guests that they can put questions in the Q&A box and we'll address those at the end of your information. So you have the floor.
All right, sounds good. All right. Start here. Okay. So just like FedOSHA, CalOSHA has said, look, you know, we see that you've made these recommendations. We're reviewing it. But, you know, while somebody in the public can, you know, maybe doesn't have to exclude themselves or go get tested, CalOSHA has been explicit in saying that you still need to follow their guidance as far as face coverings and testing requirements in the workplace. So, as Robert had mentioned, what's next in terms of regulatory environment and changes? June 15 is probably the next big date, or the first week in June when we'll learn a little bit more as far as what CalOSHA is going to do from a labor and employment standpoint. But the state has already mentioned, you know, as far as what they want to do in terms of opening the economy as of June 15. So let's get into some of the CalOSHA regulations, current state, and some of the proposed changes. And so I had sort of scrapped some of the proposed changes yesterday, thinking that, you know, they weren't going to adopt them. Now that we know it's more likely that they're going to adopt them in large part, I'm going to go a little bit quicker through what's currently in place and focus more on what is likely to happen. Particularly, we have about 20 minutes left. So, as you know, when CalOSHA implemented the emergency temporary standard, the ETS, people were up in arms because all of a sudden we have to tell people to go home for 2 weeks and we have to pay them. And that was a brand new obligation, separate and apart from paid sick leave related to COVID or otherwise. As we all know, it applied to almost everybody. The exceptions were very limited, you know, single employee workplace while people are telecommuting, or hospitals or labs, as well as homeless shelters or other places where you have close confines of people that are subject to a different standard. Employers were required to adopt prevention programs. Typically that was found in an injury and illness prevention program. I would highly advise, if you have never heard that term, or IIPP, look into it, because all employers are required to have some type of injury and illness prevention program, which addresses risks of injury in the workplace. And so COVID prevention program was supposed to be either part of that or a standalone document. The standard also required notice to any employee who may have been exposed within 1 business day, which overlapped with a state statute, which was actually passed this year, AB 685. So what happens when you have a case in the workplace, right? So under CalOSHA, you need to provide notice to other employees who may have been exposed. But in addition, the state requires companies to provide notice to potential, in addition to the employee, let's see, here we go. Anybody else that was on the premises, whether that be contractors, volunteers, really anybody else. Also, if you had more than 3 cases, then you had to provide notice to your local health agency, and you had to provide a good amount of information. And if anybody went through this, sometimes your local health agency would ask for additional information, and it became almost investigatory, which was a problem for a good amount of folks. So moving on from the notice requirements, as far as the other obligations for under the CalOSHA standard. As far as notifying other folks, this slide goes over, who you need to tell, and it's very technical, but basically there's sort of this 3 numbers that are important: 6, 15, 24. So if you had somebody who's within 6 feet of somebody who later tested positive or developed symptoms, and if they were near that person for at least 15 total minutes, not necessarily in one span, within 24 hours of their sort of infectious period or high risk exposure period, then that's somebody that you had to provide notice to. And then that person was to be excluded from the workplace for anywhere from 5 to 10 days, depending on the circumstance. And if you have questions about those technical requirements, happy to answer those questions later. As I mentioned, they're highly technical, and so I can probably forward you some handouts that would help with that. Once you tell folks that they're excluded from the workplace due to preventing the spread of COVID, then you have to provide them with their pay. And there were some questions as far as how much that would be. If it's an hourly employee, do we just simply pay them what they would have worked? Do we have to pay them overtime? At what rate do we pay them? What do we do with commission folks? There was a lot of questions, and CalOSHA never really answered that. Instead, what we had advised people is to look at the FFCRA, the Federal Emergency COVID Paid Sick Leave, as well as the California equivalent, which talked about, for commission folks taking an average, for hourly folks looking at how much they had worked and paying them equivalent of what they ordinarily would have earned. There were some exceptions, which clients were very interested in, which were very limited, and I always explain to people, exercise a lot of caution as far as determining, whether or not you're going to exclude somebody. And particularly, it's number 1 here, is that the employer can prove, note it's the employer's burden, that the exposure was not work-related. And this came up where an employee would say that my spouse or my child or my roommate tested positive. I think I got it from him or her or them, and now I have it. And employers said, that's enough, right? Well, maybe not. And each situation is different. And a lot of it is going to depend on what is going on in the workplace at the time. If you're in the middle of a major outbreak where you're having new positive cases every single day, and the person that comes to you, had 3 known exposures, probably not a good idea. But each situation is a little bit different. So I mentioned rate of pay issues, and another issue is with paid sick leave or vacation. Typically, you can't require somebody to use their vacation or their paid sick leave for this type of pay unless it's a separate entitlement that you particularly earmarked for this type of leave. What I mean there is that if an employer provided, additional supplemental COVID leave, under which, leaving the workplace due to an exposure would qualify, then you could. But the typical entitlements, you should not be applying those. Now, some information on testing. As we know, whenever you had a positive case in the workplace, you had to offer. And remember that word offer testing, because that's going to come up a little bit later, which means you sort of just provided information on where an employee could get tested, as well as, offer to pay for it, otherwise direct them in that direction. There were some additional testing requirements if you had an outbreak, which then got into weekly testing regimens, which become even more onerous if you have a major outbreak, along with some additional requirements as far as assessing, well, what additionally do we need to do in terms of physical distancing, face coverings, other sort of changes that an employer would need to make. So that's where we were, and technically still are. And we're now going to go into, well, where are we going? So this is my addition this morning to this presentation, which is the update is now postponed. The goal of a lot of the changes were to address the sort of uptick in vaccinations, what we're seeing in the research, and to address that in the workplace. Here's just some key definitions as far as what they're looking to change. And actually the third point is probably the most important one, which is they're taking a more specific approach to what is a face covering and what will qualify. I'm sure folks have gone around to the grocery store, to other businesses, and you see folks with a bandana or something like that. That is not going to pass muster under CalOSHA. So what else is going to change potentially? So again, these are all the proposed changes that CalOSHA had published and then is now reviewing. If they stick to these, then this is what we can potentially expect to see. And this is going to fall in line largely with the CDC's guidance. So for example, face coverings not required so long as everyone in the room is fully vaccinated and asymptomatic. Similarly, they would not be required for fully vaccinated folks that are outdoors and also asymptomatic, which actually is a little more restrictive than the CDC. Now there's sort of one takeaway I wanted to highlight here, which is a gap. And that is that, sure, you can ensure that your workforce is fully vaccinated. You can ask them if they're fully vaccinated, but what about patrons? If you're a customer facing business and you have folks coming in, you might not be able to ensure that everybody in the room is fully vaccinated, and you might not be able to take advantage of this new sort of relaxed guidance. So I think the takeaway here is that, stay the course for now, keep with the face coverings, and then potentially June 15th, when the state actually makes a larger move, we might be able to see a little more relaxation. Similarly, if somebody's fully vaccinated, if they've been exposed, we would expect that they wouldn't need to be excluded from the workplace so long as, one, they stay asymptomatic, but two, this gets into the timing aspect, is that they are fully vaccinated before exposure. Remember, I mentioned earlier, that's 2 weeks after their final shot. If they're exposed before that, potentially they would still need to sit out until they're cleared to return to work. All right, the 6-foot social distancing. So CalOSHA had put a hard deadline that would expire, July 31st for the workplace, with the exception of if you have an outbreak. Prior to that, distancing would still be required unless sort of distancing was not feasible or there was some exemption. Previously, it had to be impossible to take advantage. Now they just simply say whether or not it's feasible, which is actually a little bit relaxed. I wouldn't get too much into the weeds and read too much into that, because when you're under the microscope of CalOSHA, you probably don't want to be splitting hairs about whether or not it's feasible versus possible. So as far as the exemptions, so if you have a workplace where employees are required to wear respirators, then you wouldn't have to have social distancing. Fully vaccinated locations as well. So as far as a location, I put that in quotes, but CalOSHA doesn't define it. And so it's unclear whether or not that's the entire workplace or if that's certain segments of the workplace, i.e., a floor of a building, or, any buildings that are connected by a hallway. That's still unclear. But one note here is that you still must provide respirators for voluntary use to employees. And CalOSHA has been nice enough to define respirators as N95 or something higher level than that. And you have to provide those simply to your non-vaccinated employees who are also being tested. And so that's still pretty onerous, to be honest. because you're still going to have a testing regimen. You're still going to be providing masks, all to get around a social distancing requirement. So that one, it's probably going to depend on what your business needs in terms of compliance. Some other physical requirements as far as like partitions and things of that nature. Again, that should go away July 31st. Before then, if social distancing is not maintained, then you have to have a partition. Whereas potentially, if you can have distancing, if you can otherwise comply, then you might not need partitions. Which is actually really nice and a welcomed relaxation of the standards. This last bullet point, it was an interesting change, which is that previously, you weren't supposed to allow folks to share devices or commonly touched surfaces. Under the new standard, that might go away, such that folks can use different equipment that wouldn't qualify for masks or other things, but other equipment in the workplace. So here's one that Robert mentioned as well, which was N95s. And if there hasn't already been a run on N95s, I would anticipate that there will be if CalOSHA sticks to the proposed regulations in terms of masks. As we all saw when COVID first hit, it was near impossible to get masks. And now with CalOSHA defining, almost like designating a preferred one, I would anticipate those might be in short supply. But going to the standard is that starting July 31st, you must provide them for voluntary use to anybody not vaccinated who is working indoors. And so I would pay close attention to the regulations on that, because that's an added expense and the availability might not be there, and that might be outside your control. As far as notifications of a potential exposure, mostly the same, except there's an additional verbal follow-up. And what happens is that if you have reason to believe that an employee didn't receive the notice, or if you have a workforce with limited literacy in the language used in the notice, then you need to provide verbal notice, verbal follow-up to make sure that they receive the notice. And so that's actually an easy fix, is that if you have a workforce where a large portion of them speak a language, more than one language, then provide the notice in both English and whatever language it is. My first bullet point is pretty clear. This is not helpful in terms of the continuation of pay requirement. In fact, this fourth bullet point, they've defined it as the regular rate. Anybody familiar with overtime calculations knows that the regular rate can be complicated, particularly with people who are more than just hourly or have some type of incentive pay. This one's probably going to be under consideration to see how you calculate, what folks receive when they're being excluded from the workplace. The other not so great news is that they've explicitly said that this is subject to enforcement through existing law. And if you're familiar with the PAGA statute, or Private Attorneys General Act statute, which provides for civil penalties by plaintiffs in the wage and hour context, I would anticipate that you might start seeing PAGA lawsuits regarding CalOSHA enforcement related to this pay issue. It's highly technical, really convoluted, but it's something definitely to keep an eye on. And I would highly advise seeking counsel if you have any questions about calculating how to pay folks when they're being excluded from the workplace. So as far as testing, previously I mentioned that you had to offer testing. Now it's make it available at no cost to the employees who may have COVID symptoms and they're not fully vaccinated. There's not a ton of information as far as what that means or how that's different, but I would anticipate that that would mean that it's more than simply providing them a sheet of paper with information, and it may actually require maybe some additional financial obligations. So stay tuned to see where that one ends up. This is just making that clarification. And again, highlighting that 6/15/24 rule to determine who might be subject to this. But the good news, again, is that if you have a workforce that's fully vaccinated or is near fully vaccinated, then they would be exempt from that requirement. So that was, the last one on outbreaks. Again, relaxed requirements if you have vaccinated folks, but otherwise, the social distancing or other partitions or other safety requirements, while CalOSHA might relax the testing requirement in terms of an outbreak, they are leaving in that if you have an outbreak, then you do need to put back in place other social distancing, partitions, and things like that. So it's relaxing the standard in terms of testing, but not in terms of other safety devices. The other additional requirement is that you would need to determine whether or not you need to offer respiratory protection, or they explicitly put in the regulations, considering halting operations, which obviously no business wants to hear, particularly after this last year that we had. So, nearing the end here, some sort of takeaways, recommendations. Make sure that you have a compliant written COVID prevention program in place. Maintain the 6 feet rule for now. Enforce mask wearing for now. Permit working from home if it's possible. If you don't already have some template notices, have those ready. If you haven't already looked into testing resources, I would highly recommend doing so that way you're ready. And then, train your folks so that they're able to respond. And I think that's pretty much all of my time. I didn't leave a ton of time for questions, and I know that that was a whole lot of information. Kathleen, any particular questions you want me to address quickly, or any questions that you had that I could sort of address?
Sure, we have 2 questions, and I'll just read them off to you. One is workers' comp question regarding callbacks in SB 93. Are employers required to call back staff that have opened workers' comp claims?
I believe the answer is yes to that one, but it depends on what type of leave it is. So I would probably want to know a little bit more facts about that, if there was any other statutes in play, and similarly where the status of the comp claim is. So rule of thumb is probably yes, but I'd probably want to take a closer look because that sounds a little fact specific.
Okay. I'll be sure to make sure that that individual has your contact information.
Okay.
And then next up, can KN95 masks be used in place of the N95 mask?
I will be, let me change this real quick. Stop sharing. I will be honest, I do not believe so, but I will double check that for you. Because they were pretty explicit that they said N95. And if I remember correctly, the difference is the sort of level of particulates that one protects you, the level of protection as opposed to the other. And so I'd have to probably take a second look and get back to you on that one. My hunch is probably not, but I wouldn't say don't do anything. If that is your only substitute, then I would say go with it. It just might not be in technical compliance.
Good. So do we have any other questions out there from our attendees? If not, I wanted to say thank you so much, Ashton, for a wealth of knowledge. We look forward to the upcoming updates, hopefully by June 15th, the first week of June is when I'm hearing. And we will plan a follow-up webinar so that we can disseminate the proper information to all of our partners here in Anaheim. And we look forward to having you on again.
You're very welcome. This is great.
Wonderful. And if anyone would like the deck that Ashton provided or a copy of this recording, please reach out to me at kathleen@anaheimchamber.org, and I'd be happy to provide that. Everyone have a wonderful Thursday and roll into the weekend safely. Take care. And until next time, we'll see you soon. Thanks, Ashton.
Thank you.